the Practical Training Academy's AI Prompt Engineering Masterclass. During the last session, we focused on AI as it works in legal practice, prompt structure, user cases, and improving outputs. Today, we'll move to some of the harder questions, but that will be after a recap of what was learned in the first session. Today, we'll be looking at the ethical use of AI and how AI can also, you'll also be going home with a prompt kit, and also we'll be looking at the real risk of using AI. And what I'm sure a lot of us would want to know, how can we actually integrate AI into our legal practice in a way that it will deliver results? As usual, this session would be practical, and by the end of this, combined with the first and second session, you should not just understand AI, you will also be able to learn how to use it safely and effectively in your everyday work. First, some housekeeping. We'll actually keep it as interactive as possible, and we'll love you to drop your questions in the chat box. And where it is necessary, I would come in to clarify or push the discussion further. We also like to inform you that the first session is available on YouTube, and all you have to do is to go to YouTube and type the Practical Training Academy. All our videos have been uploaded therein. So let's go straight. I know the first session I introduced our facilitators, but again, since for the people that are new, let me do a very brief but powerful introductions of our facilitators. Rotimi Ogunyemi is our first facilitator and is considered as one of the leading authorities on technology and how technology has been adapted into Nigerian law. He is deeply involved in shaping how law responds to technology. Mr. Rotimi is a partner at BOC Legal, where he leads advisory work across AI, data governance, cybersecurity, and platform regulation. Within the Nigerian Bar Association, he has played significant roles in driving digital transformation. He has served on the 9BA Digital Committee and contributed to national electoral reforms and technology governance. Is involved at the national level with the Standard Organization of Nigeria on digital trade and service framework. What makes his perspective particularly valuable is that he's not just looking at AI as a tool, but as a regulatory and governance issue, as something that will shape how our practice would be going forward. Mr. Rotimi, sir, you're welcome once again. Let me quickly now introduce all the way from London in England. We go all over the world to get you the best facilitators. And it gives me great pleasure to introduce Judith Olo, who is the founder of Braca Solutions, a legal and legal technology consultancy advising law firms and in-house teams across multiple jurisdictions on how to deploy AI and legal technology in a way that delivers measurable results. Judith has over a decade of experience in complex cross-border transactions, and which includes project finance and merger and acquisitions, and has worked at leading global institutions such as White & Case and Total Energies. During this time, she was directly involved in early stage AI and automation initiatives within legal operations. What distinguishes our work is its focus on execution, helping legal teams move from interest in AI to actual adoption with clear improvements in speed, quality, and delivery. It gives me great pleasure to welcome Judith. I will now hand over to the facilitators, and in between, if there is any need for us to intervene again, we'll come back on. And please, again, I repeat, you can drop your questions, and as much as possible, we would try to get the facilitators to answer them as we go along. Rotimi, please, you're on.
Thank you very much, Idris. Thank you to everyone in the house this afternoon. I want to say welcome back to day 2 of prompt engineering for lawyers, AI for lawyers. Also, let me welcome warmly those of you who were with us on day 1. And perhaps those who may be joining us today for the first time. Now, because of the gap between both sessions, I want to use the next few minutes very briefly to reconnect the dots and bring everyone fully into this conversation. So, on day 1, we laid the foundation for this masterclass. We actually began by looking at what AI can do and what it cannot do in legal work. And the point that was very important is that AI can be very, very useful, but only when it is used with discipline. AI is not an oracle. It is not a substitute for legal judgment. In fact, it is not a legal database. It does not possess a database of truth. And so pretty much it's a tool that lawyers can use to structure their work, to organize information, to generate first drafts, to perhaps review and refine, and overall to improve productivity. But that's only for those lawyers who know how to instruct it properly. And that's what brings us to the heart of this masterclass, prompt engineering for lawyers. For those who are with us for the first time, in simple terms, prompt engineering for lawyers is the discipline, or well, let me say it is a disciplined way of briefing, of instructing AI so that it produces output that is actually useful for legal practice. Let me say that again. Prompt engineering for lawyers is the disciplined way of briefing, of instructing AI so that it produces output that is useful in legal practice. So we do not speak to AI casually the way we say, oh, generate an image for for me to put on my profile or any such thing. Or we do not use vague terms like help me with this issue and then we hope for the best. No, we actually do a few things. And on day one, we introduced the 6-element framework. The framework was pretty much us saying every serious legal prompt must have 6 parts. To bring that home, let me put on the screen the same picture or the same image to, going way down. So every single prompt must have 6 elements, 6 parts. What is the task you are instructing the AI to do? What role should the AI play? What context does it need? What output format do you want? And what verification instruction must govern the response of the AI? And then what boundaries must it not cross? So these 6 elements is really the spine of the masterclass. And like you heard our moderators, but
Rotimi, please, you are muted. If you could just unmute yourself, check yourself. We can't hear you, or at least I can't hear you from my own end. Can everyone else hear? If you can hear, can you just put...
Okay, can someone
fantastic.
else who can speak
Yes, we're
just
hearing you
confirm?
now. We're hearing you
Okay,
now.
okay. Sorry about that. All right,
No
so I
problem.
was just landing where I wanted to take off from today by saying the 6 elements I just spoke about, which we did on day 1, we applied it to 5 different patterns. And the 5 patterns pretty much are what I would say are the applications most lawyers will default to when you use AI: legal research, drafting, and that's whether it's transactional work or litigation work. Pattern C is contract review. Pattern D is due diligence. And pattern E is, you have on the screen there, advisory memo, or what we call legal opinion. So we walked through pattern A and a bit of pattern B. So I'm going to take pattern C, D, and E together, and I'm going to do it very quickly. Again, this is almost like a recap, all right? So now that I have given you the foundation, what do I mean by applying AI to pattern D, pattern C, D, and E? Let me first of all refer you to the playbook. So the playbook is this document we shared on day 1. And we shared that document so that you can follow the masterclass very seamlessly and very quickly. All the prompts that I will be referring to have been detailed in the playbook. All right. So for those who did not join us in day 1, the playbook will be dropped or is dropped in the chat. All you need to do is to download it and open it up to the designated page. Now, if you struggle with that, maybe you are driving, you're on the move, don't worry. I will walk us through, and then you only need to go do the work when you get home or when you get back to the office, however it is for you today. So the link is in the chat. And I hope that everyone, especially those who are joining us for the first time, are able to download the document and you can follow just looking at that document. So pattern C is contract review. I see some hands up. If the challenge is you are not getting the link, you are not seeing the link, it's going to be dropped again in the chat, and then you can download it and follow through. All right. So pattern C is contract review. Again, what I am doing is I am applying the 6 elements of prompt engineering, the 6 elements of instructing an AI in the way that it's useful for legal practice. I am applying it to contract review. So this is for those situations where you need a clause by clause risk analysis, say, of a contract. So the design principle of pattern C is this, and this is best practice. When you are instructing an AI to review a contract for you, always ask for a table. Don't ask for a narrative. This is what I mean. When you say to the AI just blandly, review this contract and tell me what is wrong, I promise you, what you will get, I look great. But really, all you are getting is an unstructured essay that is difficult to act on. And then the errors in there might also be very easy to overlook. But when you ask the AI to do that review using a table, then you are forcing the AI to work. And when you look in your playbook, you will see that the table you would ask for by your prompt has at least 5 columns. So you have this contract. Column 1, you are saying, give me this output, but I want you to be specific which clause the issue that I want you to give this output on, which clause is it in this entire body of contract? Number 2, identify the issue. What is the problem? Number 3, what is the legal compliance issue? Number 4, what is the risk? You all know lawyers, we are all about risk. Is it high? Is it medium? Is it low? And I'm going to explain. Then number 5, what should the client ask for? Like I said, what this does is it forces the AI to be specific. The AI cannot hide behind generalities. So if you look at pattern D, the worked example, and I'm saying refer to your playbook now. If you look at pattern D, watch the draft. It's first of all refers to a role. Now, notice that okay, I think I should be referring you to pattern C. I'm sorry, not pattern D. Pattern C is what I should be referring you to, contract review, right? Now, and I think this is on page 11 of your playbook. This is on page 11 of your playbook. If you open the templates, look at the clause I have in there as an example. Role. You are a Nigerian, you state your practice area. Reviewing what kind of agreement. On behalf of, you describe the client. Then you give it the tax. Then you give it the context. Then you give it the output format. And the output format, like I said to you, best if you ask it to give it to you in a table. Then you give it the verification instruction and the boundaries. Now, if you look in the same page 11 of your playbook, look at the part that says worked example. Worked example. Now, I have given you the entire clause. I would only read the role part. The role says you are a Nigerian commercial lawyer reviewing a data processing agreement on behalf of a Nigerian data controller. That's your client. The client is a healthcare company subject to the Nigeria Data Protection Act. Notice what you have done in there. You have defined a role. I mean, you are not playing around. You are not just saying, review something for me. No. Then look at the tax. You say, review the following data processing agreement clause and produce a risk analysis table, identifying, notice you detailed what you want. Clauses that are non-compliant with or inadequate under the Nigeria Data Protection Act. Clauses that are unfavorable to the client. And then recommended red lines or alternative position under each flag issue. I want you to observe the details. First of all, the format is in a table format. The AI cannot hide behind generalities when it has to fill a table. Secondly, it gives you an output that is almost client ready. You can attach this table to a client's email and then with an executive summary. Like I said, the worked example is in your playbook. I would ask again for my assistant to put the playbook link in the chat. Download the playbook, go to page 11, and you would see exactly what I am talking about. I'm giving you the structure of a prompt that you can use to review a contract. Now, I want to go quickly to pattern D, which is another way you use AI for due diligence. Now, I am moving away from contract review and I'm going to due diligence. Now, this is a template you can use to generate a structured due diligence request. All right. Now, let's quickly walk through pattern D, due diligence. You see, the reason why I am taking us through this, and you'll find it on page 12 of your playbook. Due diligence is when you use AI for due diligence, that's one of the strongest use cases you can use AI for in legal practice. The reason is because the risk of an AI error in due diligence is actually very low. In fact, the worst outcome of a due diligence request is that it is incomplete, right? Which means you add the missing items. So pattern D is asking the AI to produce a request list under a defined heading, with each item tied to a specific regulatory requirement. So the example I'm using here, pages 12 and 13 on your playbook, is for a Nigerian fintech. All right. So that's the example I'm using. The context is this is a fintech that is licensed by the CBN, and it wants to acquire some other outfit. All right. Now look at your checklist again. Look at page 12 into page. Let's go to page 13 on your playbook. I want you to look at page 13 on your playbook. Look at the worked example, not the template. Page 13, look at the worked example. I want you to look at the role. The role says you are a Nigerian M&A lawyer, a merger and acquisition lawyer, conducting legal due diligence on behalf of a private equity fund. That's an acquirer who is looking to acquire 60% controlling shares in a Nigerian fintech startup licensed by the Central Bank of Nigeria as a payment service provider. Now, remember, you are the lawyer. Your job is to conduct due diligence on this fintech startup on behalf of the private equity fund. All right. So look at the tax. The tax is produce a structured legal due diligence request list covering the material legal risk areas for this transaction. Then look at the context. The target company, that is the fintech, has approximately 200 employees, processes mobile payments for X number of registered users. Look at the outputs. Produce the request list organized under the following headings. and I listed the headings 1 to 8. Look at the verification instruction. Look at the boundaries. What does that teach you? Well, it says the pattern actually makes it such that by the time you get an output from this AI, it will be detailed, it will be exhaustive, it will cover the whole 9 yards, such that when you are reviewing and applying your human judgment, you are just crossing T's and you are dotting I's. Finally, let's look at the last pattern, pattern E. That is your advisory memorandum, or what we call your legal opinion. I dare say that this is perhaps the most high-stake use case of AI, because you are advising your clients in writing, and your client is going to be relying on your advice. Let me pause again by saying everything I'm saying here is in the playbook. If you have not gotten the playbook, just look in the chat. Download the playbook and go to page 14. What I'm doing is applying the 6 elements of prompt engineering to different use cases. I have applied it to contract review. I've applied it to due diligence. And now I want to apply the use of an AI to writing your legal opinion. The first thing you must note if you will use AI to write a legal opinion is that your mindset must be one of maximum verification and maximum caution. Now, if you look at pattern E, I'm on page 14 of the play, you would see that I have given you the templates, but go down the second half of page 14, you will see that I have an example that I have worked out completely. It says, look at the role. You are a senior Nigerian technology and cyber law associate. Remember, this is just an example. You could apply this template to whatever area of expertise that you work in. I'm only using this area because this is my area of expertise. Now, what is the tax? The tax is advise the client on its potential criminal and civil liability exposure under the Cybercrime Act of 2015 as amended following a data breach. Now, I will stop at the context, but I want you to understand the details. Look at the context. The client is a Nigerian e-commerce company. That's my client. On 20th January 2026, an attacker, that's a hacker, exploited a SQL injection, that's a way hackers operate, vulnerability in the client's website to extract customer personal data. That's name, email, addresses, phone number, payment card information for approximately 12,000 customers. Now, stay with me. The client became aware of the breach on 25th of January 2026. Notice the extra details I'm giving. No customer funds were directly stolen, even though the attacker obtained their card data, but there is no confirmed evidence of fraudulent transactions. The client has retained an external cybersecurity firm and taken the affected system offline. The client has not yet reported to any regulatory or law enforcement authority. Notice the details I have given in the context. Now, look at the output format. I'm still on page 14. I now say to the AI, structure the legal opinion with the following headings. Give me the facts as understood. 2, give me the legal issues identified. 3, analyze criminal liability under the Cybercrime Act. 4, analyze civil liability. 5, tell me the regulatory reporting obligations. 6, risk assessment. Now, I would pause there and say to you, this forces the AI to act the same way you would expect your junior associate to act, with intention, deliberately, and with focus. And this is how you use the tools. The worked example is in the playbook in details. And I want to emphasize something about when you use AI for legal opinion. This is one area where you should never accept the AI output without comprehensive line-by-line verification. Not just glossing through, not just spot checking line by line. Every citation checked, every proposition verified. And when you follow these rules, whether it's pattern A, B, C, D, or E, the framework makes the AI output better. Do not forget, you are the lawyer. The AI is the assistant. And so you force the AI to give you what you want, and you still review. Now I am about done, but let me recap, and then I will turn it over to Judith. Pattern A, legal research. You ask for a plan, not an answer. The AI structures the inquiry and you execute the research using a verified legal source. And that could be your Nigerian Weekly Law Report. It could be your Law Pavilion. 2, drafting skeleton. Pattern B, ask the AI for structure before you ask it for content. The AI builds the architecture and you draft the substance. We covered A and B on day 1, and you can go check the video. Today, I walked you through contract review, due diligence, and writing legal opinion. I don't know which one you would want to start out with first, but whichever one it is, I am seriously hoping, I am beyond hoping that you will take the lessons learned from this module and you apply it. So then, that brings us to the end of module 3. Now, if you had gone through module 1, 2, 3, you have 3 things. You have the framework, you have the patterns, you have the verification protocol, and you have the structure. But today, we are going to go into something more intense, something more deliberate, something more intentional. And to lead you through this, I will be handing you over to Judith. As you heard at the start of the class, Judith is the founder and lead consultant at Bradshaw Solutions Limited in London. She advises clients on AI governance, compliance, and risk management. She's going to take you through the SAFE protocol, a practical workflow that she has tried and tested, and in fact, advised clients on. And so, Judith, over to you. Thank you very much. Judith, your mic
Thank you
is
very much, Rotimi. Can you hear me?
absolutely.
Yes, I'm sorting out the sharing of the screen. Can everyone see my screen all right?
Yes, we can. Yes, we
Okay,
can.
fantastic. Thank you so much again, Rotimi, for that wonderful introduction. So today, as Rotimi has said, I'll be delivering module 4 and we'll introduce the SAFE protocol. But before we get into the framework, I want to start with where most lawyers are right now. Last week, I was speaking with a legal team, and they told me that they were very, very excited to have finally started using Claude and GPT for their legal workflow. And after some more conversation with them, I asked one question. Does your firm have a policy for AI use? And there was silence. The silence is the problem I want to talk about today, because that silence is not unique to one legal team. It is everywhere. Studies show that 79% of legal professionals are already using generative AI tools in their practice. But here is the problem. Only about 21% of organizations have a formal policy in place. That is a 58-point gap between adoption and governance. Let me say that again using other words. Nearly 8 out of 10 lawyers are using generative AI. However, fewer than 1 in 4 of their firms or organizations have a system to manage it. And that is where the risk lies. And when I say risk, I am not speaking hypothetically. 3 risks every lawyer using AI needs to understand. And these are not theoretical. Some of them we've already spoken about during the structure of the prompt engineering, but we'll lay that out more in detail so you can fully appreciate it. These are happening now and have real consequences. So I would please urge each and every one of us to take this seriously. The first risk is hallucination. Most of you already heard of this, and this is just a fancy way of saying AI can lie to you, and it does so very confidently and very convincingly. Your general purpose AI tools, that is your ChatGPT, your Claude, your Gemini, hallucinate on legal queries between 58% to 82% of the time. Even specialist legal AI tools, because I know some of you at the back of your mind will be, okay, what about specialist legal AI tools? Even specialist legal AI tools that are built for the legal industry have been found to also get things wrong more than 17% of the time. These hallucinations can lead to real consequences. And there have been a few, numerous, but I'll give you a few real life examples. Just this month, actually 2 weeks ago, an Oregon court in the Doiben case fined a lawyer $10,000 for using at least 15 fabricated case citations and at least 9 fake quotations. Also in 2025, last year, a California attorney was fined again $10,000 after a court found that 21 out of the 23 quotes he used in his appeal brief was fabricated by ChatGPT. The lawyer actually admitted that he did not read the output before filing, which, as we've heard, is a no-no and should never be done. In another case, in July of last year, in the Johnson versus Dunn case, the lawyers were disqualified from an entire case. Now, not fined, a more serious consequence. They were disqualified from representing the client for the rest of the case. And the court referred them to their state bar association for disciplinary measures. The court said monetary sanctions was not enough punishment. And this is not just a US problem. Some of you might be thinking, okay, well, but that's just in the US. In the UK this year, the High Court found that 18 out of 45 citations submitted by a solicitor were fabricated, and those lawyers were referred to their regulators for sanctions. In Africa, In South Africa, a court struck out 7 hallucinated authorities that the lawyer provided and referred that attorney for misconduct to be disciplined by their bar association. Also, a Big Four consulting firm, which I'm not going to mention, but you can go and Google it and research it, had to refund 2 governments in the hundreds of thousands of dollars after their reports were found to be full of AI fabricated references. So this is already a global problem. It's not just an isolated issue. I haven't found any published Nigerian cases on this issue, and that is precisely why the framework I will share today matters, and we're going to be ahead of the curve. So if it ever does arise in Nigeria, all of you in this session will not be the ones that are caught out. Okay, so the second risk is the breach of confidentiality. When you paste a contract wholesale into ChatGPT, Claude, or any public generative AI tool that contains the client's name, the deal values, any privileged information, you have disclosed confidential information to a third party. As a lawyer, you remember, we all have a duty not to disclose client information or privileged information without informed consent. And AI tools are not exempt from that obligation. Just last month, in a US federal court, and this was ruled for the very first time, and it actually brings this into context. In the United States versus Hepner case, the judge held that 31 documents a defendant created using the public version of Claude were not protected by attorney-client privilege. Why, you may ask? Well, frankly, because Claude is not a lawyer. Because the defendant used it without his lawyer's direction, and because the platform's own terms of service allowed the provider to access, to store, and to disclose the data. The court said there was no reasonable expectation of confidentiality. Now, this is a litigation catastrophe, and it is happening in real time. So imagine if your client's strategy ends up in the hands of opposing counsel because you used a public chatbot that is now indefensible. That is just not right, and we can't allow that to happen to us as professionals with our legal ethics in line. So the third risk is bias. In 2025, a US federal court certified a class action in Molby versus Workday. And here they were alleging that the AI hiring tools systematically discriminated against applicants based on race, age, and disability, because usually some organizations use the applicant tracking system and have AI embedded into it. Even Amazon, one of the leaders in AI and web technology, scrapped one of its own AI hiring tools after discovering it discriminated against women. So one thing that I want all of us to remember, if you use AI to assist with any advisory, research, hiring, or decision-making task, bias in the model becomes bias in your work product, and you need to watch out for that. So what happens if you do nothing and the gap remains and it's like, oh, well, I don't want to follow any of these rules? Well, these are the consequences. We've talked about the consequences. We've seen it. I'll just give a brief recap. In that gap, if you do nothing as an individual lawyer, as an organization, in your firm, in your chambers, and you keep acting as status quo, remember, lawyers are being sanctioned. They're being disqualified from the case. Client data is being leaked in an AI chatbot, and privilege is being waived. So the question is not whether to use AI, because some of you now might be thinking, oh, with all this risk, okay, let's not just use it. Let's not use it. Let's park it. No. We should be using AI, as we've spoken to you today, Rotimi and myself in the last class, and also as you'll see later on in the presentation. Using AI is great. It is useful. But the question you need to be asking yourself is whether you have a defensible system for using AI safely. So that is what I am going to give you today. Now you know the risk. What is the solution? Safe is the solution. It is a 4-step protocol that you can apply every single time you use an AI tool for legal work. It stands for scope, anonymize, force verification, evidence your process. In the next few minutes, I'm going to give you the framework for each step, enough to start implementing from tomorrow. So you can start doing this right away from tomorrow or even this evening. But I know by the time we finish, it'll be 5 p.m. and maybe some people will be done with work, but others will keep working. So you can start implementing it immediately. Each of these 4 letters is an entire training module on its own. The full implementation, the templates, the firm policies, the team training, and that is actually what I do with organizations when we work together. So for now, let me give you what you need to at least get started. S stands for scope. Before you open any AI tool, you need to classify it using a traffic light system. Green tasks are low-risk tasks, and these are brainstorming with the AI, summarizing documents that are already in the public domain. Here, you can use AI freely with light touch review. Then there are the amber tasks, and some of these Rotimi went through in the various different patterns and scenarios that he spoke about just before I came on. So the amber tasks are medium risk, drafting a first cut of a clause, reviewing a contract for common red flags, researching various different provisions. Here, you need to use AI with heavy human review and independent verification, checking the primary sources. The red tasks are very high-risk tasks, such as producing final legal advice, providing a legal memo, any document that is going to the court or the regulators for submission, your due diligence checklist, and anything that is being sent to a client. So for us lawyers, it typically means every single thing might be a red task. So when you have a red task, AI is only your research assistant. The lawyer holds the pen and is the decision maker always. Remember, the responsibility and the risk lies with you as the lawyer to check everything and to review everything. So the rule of thumb I usually give my clients, if you're in doubt, whether it's a green task or an amber task or a red task, just classify up, treat it as a red task, and you would most likely not fall into any issues. A is for anonymize. This is the step most lawyers skip. And this is actually the one that could cost you your practicing certificate, your license, get you in trouble, fined, or your organization's also fined. Because you're essentially disclosing confidential information to a third party. And who's that third party, you might ask? The AI chatbot is that third party. So before you input anything into an AI tool, especially a public-facing one, a consumer-grade level one, you need to replace every identifying information. So if we look at the prompts here on the left, I have just given a short example of an unsafe prompt. Here you have all the identifying information. You have the facility agreement between Zenith Corp and Blue Peak Limited for $50 million closing 15th of April. That is too specific and it's fully identifiable. Now, what you want to do is you want to anonymize it. And below, I have given the strictest anonymization protocol, which is where you just have the agreement in square bracket is between the client in square bracket, counterparty in square bracket, the value is in square brackets, and the closing date here is in square brackets. In some deals that are not easily identifiable or that are not niche, you don't need to follow this strict anonymization protocol. You can have a broader anonymization protocol by saying things like, a client within the banking industry, a counterparty who's in the construction company with operations in the Americas or in Nigeria or in Africa, right? And we just need to remember that this anonymization step just takes less than 5 minutes of work, especially for a short document. Let's not forget our basic computer skills, right? Use your Control F, find and replace. Replace all the identifying information. A common mistake that I actually see when I work with lawyers is that they anonymize the names, but then they leave out the deal values, the dates, the jurisdictions. And these could also be identifying information, especially in relation to a matter or a deal. So we need to remember to anonymize every identifying information. Also, don't treat public chatbots and the public versions or consumer level versions of these generic AI tools, that is your Claude, your ChatGPT, your Gemini, as internal systems. You always have to be careful of what you put into these tools. F is for force verification. This is the heart of the protocol. So do not just ask AI for an answer. You heard this last week. You've also heard this in the recap that Rotimi just gave. You need to give it the verification instructions and set the boundaries. Ask for evidence, for it to tell you when it is uncertain, when it has assumed, plus what it does not know. So we've given you in your prompt pack some of these verifying instructions and boundaries. I also spoke about it the last class. So please ensure that you do this and you are using these verification instructions and boundaries within your prompts. Not doing this invites hallucinations, as we clearly saw in the last class. However, don't forget that after you receive the output from the AI, you need to personally cross-check this. Does every statute, case law, clause actually exist? Is it real? You need to check this independently from authoritative sources. I can't re-emphasize this enough. Never let AI verify itself, because sometimes you put it into AI and say, oh, does this clause actually exist? Please verify. Don't do that. Always verify with authoritative sources. Another common mistake that lawyers usually make, especially when we're short on time, maybe a client or your boss called you late at night asking for something first thing in the morning, or your court date has just been moved up because a judge suddenly has time on their calendar. And you have to prepare weeks worth of work in just a few hours. We've all been there. You know, that feeling of, gosh, so much to do, so little time. Then what we do is we start to peruse, we spot check, we skim. You just verify one or two things. Please don't do this. Check all of them. Because if you remember, in the Dunn case, 21 out of the 26 cases were fabricated. So that means the lawyer maybe just checked one or two. If they at least checked 5 or even 3 of them, they would have found out that, oh, there's a problem and there are fabrications. So that should not be us. We should make sure we check every single output that the AI tool is giving us. Even when it's analyzing contracts for you, check the clause. Does that clause actually say what the AI tool says? Does that clause even exist within the contract? Because sometimes it makes these things up. So we need to always check. And the next step is E. E is for evidence. This is what separates a lawyer who just uses AI from a lawyer who uses AI defensively. Now, what I am about to share is the part of today's session that I want every partner, every GC, and every member of an executive committee to hear, because this is where governance lives. This is the part that protects the firm, that protects your corporation, that protects your chambers, and not just the individual lawyer. Let me ask you something, and just think about it. If tomorrow a client, a judge perhaps, a regulator, or even your board should ask you, in your organization or in your firm or in your chambers, and they ask you to prove exactly how a piece of work was produced. Could you do that? As you sit with that question, just remember, every time anyone in your organization uses AI for client work, they must log these things. And these are the 6 things they need to log at the barest minimum: the date and matter or project reference, the task description, the tool used, including the name of the tool and the version, the prompt entered. This is why it's great for you to structure your prompts in the ways that we've been talking about in the last class and in this class in prompt engineering. So the prompt that you entered, the output you received from the AI tool, and what you changed and what you checked, and who was the person who reviewed this. Think of it like this, right? In a project finance deal, nobody closes $1 billion transaction without a CP checklist. In a due diligence, we keep document request logs and we keep the due diligence questionnaire, right? In M&A transactions, we track completion steps. In a litigation, we will never file a witness statement without proof of evidence on the matter file. So AI is not exempt from that same professional discipline. And lawyers also make another common mistake of assuming sending an email to their team to make sure they use AI safely counts as policy. It actually does not. It does not count as policy. You need a fully documented and fit for purpose policy and a systematic log of AI use for your audit trail. This protects your firm, your organization, your chambers, and each individual lawyer. So you need to start with what you have, right? And I know some people don't have complex systems. Start with what you have, start with where you are. It can be as simple as a spreadsheet, either in a Word document or an Excel spreadsheet that is shared within the team and that has 6 columns where these 6 things, as displayed on the screen and that I went through, are inputted. So every time you use AI for legal work, remember to run the SAFE protocol. S, is this green, amber, or red task? A, have I stripped out every identifier? F, have I told AI to flag uncertainties, created boundaries for it, and have I personally or the lawyers within my team, have they verified every citation independently? And E, can I show a judge, a regulator, my client, or my board exactly how I got the answer because I have an audit trail? If you can answer yes to all 4 of these, you are using AI defensively. However, if you cannot, you need to stop. Go back and fix what is missing. So I look forward to hearing how you implement this in your firms, in your organizations, in your chambers, and I would love to stay connected. If you scan the QR code on the screen, you'll find me on LinkedIn, connect with me, tell me one thing you're going to do differently after today's session. But before I leave you, I want to say this. Remember that technology is a tool. Integrity is our profession. So we need to master the tools, but we never lose that integrity. And if your firm or organization wants to go deeper, build AI policies, train your teams, implement defensible workflows, I would be glad to continue that conversation. Thank you for your time. Thank you for your attention. And now I hand back over to Rotimi.
Fantastic, fantastic. Thank you so much, Judith. Thank you so much. Idris, I was wondering, could we just pause and take questions? Because I'll be going into a lab session now. Maybe it might be helpful.
Yes, we can do that. there have been a lot of questions that already started coming in. So let me quickly go to the Q&A and see if there's anyone I can pick out from there. I'm sure even the discussions of the questions would help us see how it is. Most people are asking for the slides, particularly that's from Judith. I don't know if Judith, and also from you, Rotimi, your first slides that you did use for the first training, and the one that you've, okay, today's one was basically on the playbook. So, but at least the slides you used for the first module 1 and module 2, is it possible for at least the participants to get this?
Absolutely. You get it right after now.
All right, then. Thank you so much. Straight up to the questions then. Again, I reiterate to all participants that you could ask questions in the Q&A. I can see that most of the questions have not been dropped therein, but let me just check on the chat, see if there are any questions. Just 1 minute, please. Seems your explanations have been very good. Most times, the only thing they're asking for here in the Q&A is the link to the chart and the link to the playbook. And okay, I've seen one here. Now, this is from Ebuka Obidima. Okay, it says, when we are drafting a criminal statement, e.g. on rape, and AI, e.g. ChatGPT, flags the entire statement on the basis that the content is against its guidelines. What can we do to stop that from happening? Rotimi.
Okay.
What essentially I think is asking is where the AI itself does not answer the question due to its own rules.
Okay, so very high level, let me say that everything we've been teaching here about prompting, the AI itself, it's called system prompting. The AI has been prompted at a systems level to respond to certain questions and not to respond to certain questions. And the guardrails are a lot of things: national security, decency, harmful content. There are just a number of guardrails that the AI would flag and not respond to. But I think the short answer in this case is also prompting. So it's most likely the prompt came across as instructing the AI to go into certain details that bordered on, in other contexts might be called child pornography, in other contexts might be indecent, in other contexts might just be porn, right? So the context matters. I imagine
Okay, Rotimi, it seems as if we've lost you. Rotimi, can you hear me? Oh, okay. It seems as if we have until Rotimi gets back. Judith, are you here? Are you there with us?
Yes, I'm here. It seems Rotimi has been kicked
Yes.
out. He'll probably join
Can you
soon.
just your own thoughts on the question that's just been asked? Why do AI tools reject certain particular contexts or seems to have been programmed not to answer certain things?
Yeah, so just as Rotimi has said, and I think he did justice to that, to the answer of that question, what I would add is, again, the framing of the prompt, right? You don't want to be being so vulgar in your typing or using such explicit details of what happened in that rape case. You can structure it more diligently, right? And say there was a sexual violation on somebody, right? And put the details in a more discrete and cohesive way. That way, obviously, the AI will give you answers back because, again, rape, sexual violence, they're real things and there are court cases on them and they're information that the AI has been trained. But as Rotimi said, and to build on that, if it seems as you're asking the tool to produce sexually explicit, pornographic, indecent, child pornography, trafficking information that it looks like you're prompting it to aid you in those things, you won't get an answer. So you need to be prompting it discreetly and diligently, right? To get the answer that you're looking for, but in a safe way as well.
Okay, thank you. And this question,
Thank
I
you.
think, all right. Do you want to add anything again, Rotimi?
No, well said.
Okay, this one, Judith, I want you to take it because it goes to the core of what you had said. And this has to do with, I don't know whether this is something that will be done in the blab session, but let me quickly throw out this question and you can answer it briefly. What should a serious law firm put in place immediately? Is it a policy? Is it training or is it restrictions?
So
Judith.
it depends on where the serious law firm is at the moment, right? Have they started using tools? Have they not started using tools? Where are they in their journey and in their process? What they should put in place immediately, they should put the safe protocol in place because within it will guide what they put in their policy. Again, they also need to be training their lawyers, right? And most of the lawyers hopefully are on this session, but that's one of the first things you need to do because if you have a tool and you're not training your lawyers on how to use it properly or you tell them not to use it, guess what? They'll use it. And there's a term already known for it. It's called shadow AI. They'll use it on their personal phones and they'll put client sensitive information on their personal phones that is not covered within the protections of the firm and under the insurance, right? And it can even, if God forbid the firm is sued, it can permeate the insurance protections, your professional insurance that you have. So all of it is important to do in a stage process immediately, but starting out, start with the training, put in place the safe protocol immediately, and take it from there. Again, depending on what you're trying to use the AI for, what work product, is it in litigation? Is it in a client deal? Is it in a research brief? What department? What kind of information are you trying to feed into the AI tool? This all matters to then what is included in the AI policy and the extent of the training that your lawyers in the particular law firm or organization need.
Okay, thank you. This is from Nta. Nta is a director with Tpta, and she says, "Hi, Judith. Please, I have a question. Please, can you talk us briefly through anonymize? I believe that this is also using AI to do this. Please, can you recommend tools/tips on how to do this efficiently and effectively, especially for legal research in the academia?" Judith.
Okay, thank you for that question, and that's a good question. Well, I would not recommend a consumer-facing AI tool to anonymize a document for you because by giving it to the tool and telling it to anonymize, guess what? You've already given it the information. And that's all what we're trying to avoid. So they're enterprise grade tools and they're fit for purpose tools that can do this, but I won't speak about this on the call because we need to understand exactly what you're trying to anonymize, the context of it for me to be able to give helpful guidance on the type of tool to be used. But this is something that can be done internally. This is what you can give an intern to do, right? Because I know sometimes it's expensive to do it as a partner or as a senior associate. You give an intern, you give a trainee. And it's easy, Control F, find what the informations are, the client's name, the deal size, right? The deal values, right? And just include blob or client, and as we said on the anonymized slide. So it doesn't take that much time. I know it looks intimidating, especially for large documents in the hundreds and thousands of pages, but it's worth doing it, except that document is already available in the public domain, because sometimes you're working on a deal, it's already done, it's been published in an article or something, then fine, you can take it wholesale, put it in the AI tool and tell it to anonymize it. That is perfectly acceptable because it's already in the public domain. But if it is not, please don't do that.
All right. Inter has also
Just to
asked, I
add,
think you, yes. Inter
I
has
mean,
also asked to comment, Rotimi, particularly as it relates to the Nigerian lawyers context. I mean, just
um,
apply
pre
to
pretty
our
much,
Nigerian
pretty
the
much
same.
the same response. Just to say, everybody has Microsoft Word, right? Find and replace is the tool everyone has access to. And like you heard the cheat sheet right there, give it to an intern to do, right? But then there are other open source tools, open source, a little bit of technical information. They are out there. You can anonymize a 50-page, 100-page contract in seconds. And I'm saying they're open source. There are tools out there. You just need to check a little bit, right? So we can have a further conversation around.
Okay. So there are issues as it relates to governance, AI governance and regulatory. I don't know. We have not really treated that yet, but questions are coming up. Like they always say, the technology comes out first before the regulation on top of it. So I'll be asking you this one, Rotimi. Do you see Nigerian regulators moving fast enough on AI governance? Because these AI tools are being upgraded almost on a weekly basis. And some of these, as also relates to the last question, where you're saying that how do I ensure that what I am using the AI tool for is what it is meant to be used for? So are regulators moving fast enough, particularly in Nigeria, on AI governance, or are we basically operating in a vacuum?
So the short answer is there's no regulator anywhere moving fast enough. Because the technology is faster than anybody, anything, any institution. And I'll give you an example. See what happened between Anthropic and the Pentagon. How could it be that a company, right, is dictating to government, the military, to say you can't do X or Y? Well, it's because the technology is even more advanced than the military, right? The internet was developed by government, the military. Now AI is being developed by labs. The guys in these labs know more than everybody, lawyers, judges, everybody, right? So all we can do is to understand the tech. And I think it's critical we as lawyers get this. Understand that the tech is at different layers. There's the infrastructure layer, there is the model layer, there's the application layer, then there's the use, like us using it, right, layer. So when you say governance, it depends on what layer you're talking about. But I think the safest answer is at the level where we are deploying and using, then let us default to self-governance or professional governance. And that's all we've been talking about. Let's put the guardrails around the use, right? And then we use it responsibly, we use it safely. I'm not even waiting for government to regulate anything. Please, let government stay away for now. Otherwise, you cripple something and you regulate something you don't even know 5% about, right? But we must regulate eternally, firm level, personal level, professional level. That's what we should be talking about. Shorthand.
Okay, so as a quick follow-up question to that, how do you recommend that a law firm regulates the use of AI within its firm and even at the professional level that you mentioned?
If people want me to tell what Judith will bill everybody for. AI, have an eternal policy. That's number one. an AI use policy. That's where you start from. And it's little things. And honestly, these are the things Judith spent a lot of time about. What tools can you use for what? What should you, I mean, that's where you look at the green, the amber, the red, right? So have an in-house policy, that's governance. And let's be clear, we want to use the tools. The tools are powerful, right? How do we engineer it such that it's usable within the boundaries of professional rules, within the boundaries of ethics? That's what your AI use policy does. So, I mean, it's just like putting a privacy policy together, only that it's a bit deeper than that, right? But you need to understand the capability of the tools. You heard Judith say, even the specialized legal AI tools, right, are not safe from hallucination, right? So it's really the disciplined use. That's what informs your policy from wide. And then you begin to iterate as you go. You are not going to get it right 100% first go, right? You start tweaking, all right, this worked, this did not work. So yeah, that's it.
Okay, so one of the things, because I know some parts, also as part of my own work, would you recommend, and I'm talking to you, Rotimi, that, or how do you see us using AI for the judiciary, and particularly for judges? Will your framework, as it relates to the playbook and all the things that we've learned here, be also applicable considering the nature of their work for the judiciary? I think they really, really need it.
They do. And I would be very quick to say the framework, everything we have said here, day one, day two, applies to judges, right? Only that there is more. I'll give you a good example, and thankfully I would bring it from the arbitrator end and not the court litigation end. Today, as we speak here today, there is an AI arbitrator developed by the American Arbitration Association. It resolves, as of today, it resolves construction cases only, but it's paper-based. And if you, of course, for those who know the construction industry, it's a complex industry. You can have 1,000-page contracts. You can have change orders going into hundreds of pages, right? You can have drawings and all, but the AI is so positioned to work in that space. I'll tell you what the American Arbitration Association did. They trained this specialized AI on 1,500 trial construction cases. So the AI is domain specific. The AI is sound. And the AI is resolving, and so I'm not even saying future, is resolving cases today, but with a caveat, the human arbitrator review, right? But they have done, is it the research now? They've taken the survey and they found out that just by deploying this, it has saved that industry 50% of its usual cost, right? And it has cut the time in resolving these cases into half. So that is the answer to Nigeria. I think that there are some matters that has no business going to the courtroom, first of all. I mean, for instance, I erroneously transferred 50,000 naira to someone and I need a court order to reserve it. That can be resolved by email, honestly, because these things can be resolved by paper evidence. You really don't need to stand before my Lord. And so what I'm saying is, if we really have the will, we can deploy these tools safely and responsibly in the judiciary, and it's going to decongest, our courts in a way that will be almost unbelievable. So the only question is whether we are ready to do this. If we are, the technology is there. So yeah.
Yeah. So another context to which I'm asking the question, I'm still with you, because it's something I'm very interested in. Can AI tools assist judges or magistrates in writing rulings or judgments? What's
It's
your
only
view?
the ethical question. The only
Mm.
question is, do you want the AI to do it? If it's a technology question, the answer is yes. In fact, I've sat on a panel once with a judge in a state I will not mention. He said it openly. All our long arguments, he asked an AI tool to summarize it for him first. Even though he then said he reads everything. But he said it openly. The AI tool is a young judge, though. Maybe it's a Gen Z judge. I don't know. The AI tool summarizes everything for him. And that's where he even starts from. And he says it makes his work faster and easier. So, I mean, this thing is already happening. But I think we need to, I guess Judy to have a thing to say, we need to put some stricter guardrails there because you want to know that a judgment comes, it's not a robot somewhere that wrote the judgment, amongst other things. Yeah.
Judith, do you have opinions on this?
Yeah, just one thing I'll add, because Rotimi has done excellent justice to both questions that you asked him. On the judge side, I think one thing that judges need to also take into consideration, apart from ethics, is the bias, or I should say, wrapped into ethics is the bias. AI tools are trained on the data that they have. And because they're trained on data that were produced by humans, there's already the human bias that goes into the tools. And then AI exponentially creates this bias. So, for example, if it's been trained on data where, I don't know, let me switch it now, women have always been winning cases, and in particular sorts of cases, the woman always comes out favorable. Now, when you give it a case where it's a man that was going through the same issue that the woman was going through, it will come out and have the man not favorable. Where on, you know, rational judgment of the case, if the facts of the case are the same, there's precedent to handle the same thing. Just because the gender changed doesn't mean the rule should change. The law is the law, the rule is the rule. And that is where the issue with using AI for court judgments come into play. So I think it should be used, but there should be a human judge oversight, or they should use specialized tools which are made and trained and are actually trained to cut out the bias. Because what AI does is to review patterns and to predict the next thing in the flow. So if you're training it on something that gives either women or men or a particular tribe, right, preference, then it will spit that out without actually going into detail and looking at the various nuances, which only a human can do. So that will be the 2 cents. And to add to the question on the regulation, I would say a lot of companies that are operating in Nigeria operate on an international nexus, right? You work on deals with international lawyers. The companies are international organizations that have a branch in Nigeria, or a Nigerian indigenous organizations that are working on transactions with foreign companies. Do not wait for Nigeria to regulate before you start self-regulating or regulate your companies, because by very nature of having that international nexus, or just signing a dollar facility, you've already nexused yourself to the US regulators. Signing a pound or a euro facility, you've already nexused yourself, or a document governed by English law, right, or French law, you've already nexused yourself to the regulators in that particular country. So starting now, because you have the information to self-regulate and put the right things in place, will help you later down the line when the Nigerian regulators eventually start regulating.
Okay, I'm staying with you, Judith, because this one has to do with part of your presentation, and it's something you've already mentioned now. AI bias. This is from Clifford. AI bias. Does the AI produce answers to a prompt with a view of pleasing the prompter based on a study of the kind of antecedent question which may have suggested to the AI the kind of answers the prompter likes? Is this
Yes,
true?
yes. The plain answer is yes, because these tools, they are trained during the training stage. They put in all the large context of data, then they fine tune. And part of the fine tuning is where they want the AI to produce an answer that makes the user feel good, feel seen, right? And you already do this in your chat GPT or in your Claude. When it gives you an answer, you know that thumbs up or thumbs down? When you click thumbs up because it told you, oh, yes, of course, you've had such a long day, so it's understandable you didn't do this piece of work, message your boss this and that, or message the client, this and that. I'm just giving a fictitious example there. So yes, it's trained to give you back what you want, but there are ways to stop this. And one of the ways is what we taught, right? The verification instructions, putting it in there. You can even tell it, don't give me an answer to please me. You are my strategic thinking partner. Challenge me on these issues, right? Spot my blind spots. What am I not thinking of? What haven't I thought of? Challenge it, and then it will come back and say, oh, actually, if I'm trying to be honest with you or spot your blind spots, this response I gave you wasn't quite right. If you're trying to figure out your loopholes, this and this and this, I think are your loopholes. So yes, and you can actually prompt it to stop doing that, as I've just given.
Thank you. Rotimi, let me bring you back on, and I just an answer from both of you. Maybe Judith, we start with this. The models of each of these AI tools keep changing almost on a day by day basis. Are we within the legal industry underestimating the speed at which AI will disrupt our legal practice? Do you think we are, or are we not giving it enough attention? Because a lot of clients now, even during the first session, Rotimi mentioned this. People go to check these AI tools first, and before they come to you. And if you have not really up to your speed yourself, they are just cross-checking what they have. And once these models continue to grow, do we see that cliched question that AI will take our jobs one day?
I think the short answer in if we're underestimating the power of AI lawyers, the short answer is yes, based on research and the amount of uptake with the law firms and lawyers that are using the tool. There was this study that was done, and not even 1% yet are using the tool. That's globally. But a lot of lawyers are beginning to understand that there's a change, there's a trajectory coming, it's already here, we can't avoid it. But lawyers are still underestimating the speed at which they need to implement these tools, including how to use the AI tool safely within their practice. And yes, your clients are already using it, right? They're going into ChatGPT, they're using it. And sometimes they're not even using it safely. So if you as a law firm or your chambers know how to use it, it's part of where you can keep the client loyalty to show them that you understand the tools, you know how to use it. You're not also charging them exorbitantly for something that you have your specialized AI tool that is safe, probably enterprise grade, which I would recommend, is doing, and you're saving them what would maybe cost 50%, you're saving them that 50% of the cost because you're giving the low level work to the AI to do, or the repeatable work to the AI to do. And clients like that. In fact, on some of the firms that I work with, clients say, I want you to tell me the AI tools you're using, right? So they're already demanding it, especially the corporations and like in-house team, because some in-house teams, they're just two, or it's just a one-person in-house legal team. They are already deploying AI. And when they send the work to the law firm or to the chambers, what they're expecting is that risk protection layer. Because where we've gotten to now is that the AI can do the work, but AI doesn't take the risk, as we've seen in the various case law that are provided. The risk still lies with the individual lawyer and with the law firm. That's what they're paying the premium for. So I don't think AI will take our jobs. Yes, maybe in the next 10 years or 15 years, I think lawyers are still okay. But the problem is the nature in which AI has come will alternate or alter the way we provide our services as lawyers. And lawyers who are well positioned, who know how to use the tools, stay abreast, keep up with trainings, use the tools safely, will be in a better position to keep their jobs, or to keep that aspect of their jobs with their clients, and to actually win over the clients because they see them as strategic partners to solve this journey or this fear, so to speak, of what AI is bringing and introducing to the legal profession.
Rotimi, do you have a perspective on this? And maybe I could also add that will it reduce our fees or change the way how our values are priced? It's actually something that bothers a lot of lawyers. Rotimi.
Okay. Judith has answered this question pretty much. All I want to add is bringing a perspective to this engineering. Partly is to help lawyers understand the tools, the strengths, and the weaknesses, regardless of the tools, first of all, so that with the depth of your legal knowledge and then the breadth of your technical knowledge, when you use the two together, you will be 10x better than anybody on the street, lawyer or not. That's one. Two, one of the reasons why many of the demonstrations I have done here, within the guardrails, we should take them seriously, everything Judith has taught us. One of the reasons I had used the simplest tools is to say that, high sensitive classified, there are some tools you don't even touch, right? But I'm saying wherever it is you play, if you have the discipline of prompting, you can get the most out of a basic tool, especially when these tools are increasing in capability. I fear that as lawyers who, we could get paranoid and decide not to touch consumer AI tools. When we say consumer AI tools, we are talking about ChatGPT, Claude, and Gemini. We could get so fearful, and then we default only to specialized tools. And we forget that the capabilities of these consumer tools is improving at so great a rate that if my client types in something randomly in the highest grade tool deployed by Claude, and I am using quote and unquote a safe tool that is running on GPT 5, not even 5, 3.5, right? My Claude will be worried my client will be worried about me because the level of response that clients will get on a Claude 4.6, right, that is acting crazy, would be 10x better than what I get in a so-called legal tool that is using ChatGPT 3.5 as its base. So that's one of the reasons we are teaching this, that that these tools have become very good. Understand their strengths, understand their weaknesses, understand the ones you can use for what, understand how you can safely use them. Now, I said all of that as context to now answer your actual question. Just remind me what the actual question is. I have it at the back of my mind, but just so I don't go.
Legal fees.
Legal fees, exactly. Legal fees. So, and in real life, I have done work that before now will take me and 5 associates a month to do. And I'm not exaggerating. Me, myself, and I alone, I call them my tools. They work for me. I do that same work in 2 hours, and I'm not exaggerating. Quality work. And the only reason why I don't send it out is I'm sure that even the clients will be afraid that how did I churn this out quickly? So I wait 2 extra days and I'm playing around, I'm eating popcorn, I'm having fun, right? Before I send it. And to your question, I bill the same. I bill the same because I am giving value. This is not about time. I feel sorry for anyone who is still billing based on time. Hourly billing. I'm serious. Bill based on value. If you used to do it in 2 months and now you can do it in 2 hours and you know that you are giving value, bill the same thing you bill That's me. I think the Americans will say, well, if you spend less time on it, I don't know about them. But for me, I will build the same. In fact, I will build you more. How come you don't know these things? So I will even build you more. So it should not, don't feel scared, don't get worried. Just focus on using the work out and build based on value. That's all I would say.
I tend to agree with you on the speed of work, and the quality of the work will tend to improve exponentially because of the use of AI. I don't know. So I just take one or two more questions. The prompts lab, or do you want us to go straight into the
Yeah,
prompt?
let's go there, and then I'll wrap it up in worst case 15 minutes.
All right,
Then that means we'll have just some more time and we'll take the other questions.
fine,
All right.
fantastic.
And everything we've been saying now lays the foundation for what I want to do in the next few minutes. What I would have on the screen here is just telling you, now it's your turn. Everyone on this call. Yes, I'm giving you 5 minutes, but you can take 7 minutes. If you look in the chat, I have put in certain instructions in the chat. Now, so what do you do? First of all, this is your own lab. Everyone on the call. You have learned in day one, you have learned in day two. The scenario I'm giving you is a simulated scenario. Your job now in 5 minutes, your job is to write a complete structured prompt using the 6 elements we have taught in this course: task, role, context, output, format, verification instructions, and boundaries. And truly, you can use your playbook. In fact, you can turn to your playbook and go to pattern A and use the pattern A as your structure, right? What I want you to do is to look at that scenario, just in case some may have had a challenge reading it in the prompt. Your client is a Nigerian technology startup. The startup co-founder and chief technology officer has resigned and is about to join a competing company. The startup has a shareholders agreement that contains a non-compete clause. But this CTO claims the clause is unenforceable under Nigerian law. So the startup wants to know, they've come to you as the lawyer. One, whether that non-compete clause is enforceable under Nigerian law. Two, what factors a Nigerian court will consider in assessing enforceability. Three, what immediate steps the startup should take to protect its interest. So this is the question. Write a complete structured prompt using all 6 elements of the framework that will generate a useful legal research plan. Remember, what the output here is a legal research plan for the matter. So, what say you? Your 5 minutes starts now. And I will be looking in the chat. So please, technical coordinator and host, you can open the chat. If you've been able to come up with something, it doesn't have to be long. Like I said, you can look in your playbook, look at the pattern A structure, for instance, and try your hands on this. Identify what a good prompt instruction to an AI, what it would look like given the scenario that I have put in the chat. So, countdown.
just to confirm, do you want them to put the prompt in the chat box?
Yes, I want the participants to try their hands on this and give me a prompt based on the scenario I had put in the chat.
So we'll just be waiting as the responses come in the chat. Rotimi will be looking at them together with Judith to see the number of people that have been able to understand fully the way you could easily prompt and get very good answers based on the trainings that you have received. Rotimi said 5 minutes, so I think we've used about 2 already. We'll stop this at...
We have 2 more minutes.
Okay.
Okay, if you missed the first and second webinar, I hear that the first one is already on YouTube and the link is in the chat. So you can always go in there. This particular one is still ongoing and we're about to wrap it up in a very big way. All right, so again, I pasted the scenario in the chat at 4:35. We have about a minute to go. The scenario is clear and I am looking for response. Okay, I see someone say you are a senior Nigeria corporate commercial lawyer and legal research strategist with expertise in Nigeria contract law, employment law, shareholders agreement. That is fantastic. Context. The Nigerian technology startup is facing, and then you put in all of those details. Well done, well done, well done. To strengthen this, and this is from Afolabi, I'm looking out for verification, output, boundaries. Okay, yes, I see that they're assuming the matter is time sensitive and may require urgent strategic decisions, right? That is good work. All right, I see from Zinami, you're a Nigeria technology startup lawyer. CTO has resigned, the startup has a shareholders agreement, the context, right, well done, well done, well done. And again, I really applaud those 2 people who shared. I will reach out to you. Okay, Afolabi is still coming on strong. Just know that you have won the facilitator's prize. I will not name what it is. I'm going to count on the organizers to send me your details and let your details include your account number. You have won something fantastic just by trying and by posting in the chat. So, what am I going
so
to
that
do
we
now?
do not lose some people. There are some answers that are also being put in the Q&A session of the Zoom. So if you may look at it, there are a couple of answers that are there.
All righty, let
There's
me
one
quickly.
from Alaso Adura Motunrayo. So I think she's the only one that went to the Q&A session.
Okay, please let the organizers note all of these folks. I really appreciate that you went above and beyond within these 5 minutes to try your hands. But the truth is, this is the way you are going to get very good at doing this. So I'm going to post the model answer in the chat. I will post the model answer in the chat, and I will just invite everyone to review the model answer. Okay, for whatever reason, it looks like I'm being restricted from posting in the chat. All right, so what I'm going to do is I'm going to share my screen so that you can see the model answer just directly from my screen. Okay, give me a second. All right, so the model answer is what you have on the screen. You are a senior Nigeria commercial litigation associate with expertise in employment law, restrictive covenants, and shareholder disputes under Nigerian law. Tax. Produce a structured legal research plan identifying the key issues, the applicable legal sources to consult, the research steps required for assessing the enforceability of a non-compete clause in a shareholders agreement under Nigerian law. Very important. Context. The client is a Nigeria technology startup. One of its co-founders who served as CTO has resigned and intends to join a direct competitor. Now I'm going to go down and look at what I'm asking. Whether the non-compete clause is enforceable under Nigerian law, what factors a Nigerian court will consider, and what immediate steps the startup should take. If I were you, I will probably be screenshotting, right? And look at my output format. I said, structure your response as a research plan with 5 numbered sections. And if you look at the playbook and you look at pattern A, you would see that I'm using the same structure. This is how I want you to give me the response. Legal issues identified, applicable Nigerian legislation and legal principles, applicable case law, the research step in priority order, and key questions remaining. But most importantly, look at the verification instructions. I said for legislation, cite the specific act and section. Look at the case law. I said identify the legal position to be established and describe the type of authority that will support it. But do not invent specific case names or citations. And then look at my verification tag. I said, flag any area of uncertainty with in quotes, or sorry, in a brace, verify. Then look at the boundaries. I said, this is a preliminary research plan for review by the supervising partner. This is not legal advice. You remember Judith said something about that. Do not state conclusions about whether the non-compete clause is or is not enforceable. Leave that for me, the lawyer, to judge. Do not reproduce any parties identifying information. And lastly, this is the rules of professional conduct. I said, treat all information as confidential and privileged. Now, that might sound like, oh, why am I saying that? Well, what it then means is, first of all, if you look at this entire prompt, there is nowhere that I put in information that can identify my client. There is nowhere that I put in information that anyone can piece 2 and 2 together and say, oh, this is what I'm talking about. Not even the AI, as great as it is. But when I get the response, all I need to do is to attach the response back to the actual data that I know, only I know. And I put that together and I have a research path. I have taken time to show us this and to walk us through this, because at the end of the day, where did we start from? We said we wanted to find a disciplined way to use AI, a way that you bring in your legal knowledge, a way that ensures that even if your clients are using these tools, they will still come to you. They will still come to you because there is trust in the quality of output you churn out. Trust because you are not just recklessly asking the AI random questions. You are bringing your legal knowledge to play, even to ask the questions. That is what will stand you out. That is what will ensure that you remain an expert and you are not outsourcing your thinking to this. We have come full circle. And before I turn it over back to the moderator, there's one more thing I want to share. And I hope as I speak, that will go into the chat. I call it the prompt kit for lawyers. The prompt kit for lawyers, right? This prompt kit, it has just been shared now. What it has done is it has 5 components. Many of the prompts that were in the playbook, I have put everything together, including the master prompt, and put it together with the 6 elements in that kit. You can open it on your decks and you are ready to use it on your next matter, on your next case. The second thing in that kit is the 5 pattern prompts cards. You can use it as a guide to draw up your prompting. And then you have a verification checklist, which piggybacks on what Judith taught. Then you have 10 red flags you can use to check any AI output. And then you have the final component, which is something you can use to categorize the kind of AI tools you use. And with that as my final gift to you all, on behalf of myself and Judith, I say thank you for listening to us, and God bless you. Back to you, moderator.
Thank you once more, Mr. Rotimi. I do a lot of work in this space, and I must tell you that what Mr. Rotimi and Judith have given you are top-notch, very, very top-notch materials, and they have also given us the requisite skills to take full advantage of AI. A lot of people, even from the stats that Judith has given us, a lot of people are using AI now. The question is, how many of them are using it properly? If we take advantage of this, of the things that we have been taught today, we'll go a step further. Having said all of this, it is just to close, basically, and to thank Mr. Rotimi Ogunyemi and Judith Olo for coming in, taking billable time, although Rotimi has now said that nobody looks at time any longer, is the value you are providing. Even if we look at it from that perspective, the value gained and received today is enormous. The prompt kit, the playbook, I'm going to make it my, I've already downloaded all of them onto my system, and it's going to be my guidance going forward. Just to acknowledge the presence of a couple of people. Mr. Victor Wakasi was here. Yes, he's still here. Victor and Inta are directors of the Practical Training Academy. We also acknowledge Sarah Omega Ajijola and Jimwa Mzwabta. They're from the ICLE. They are the regulators for our regulators. We thank you all for being a part of this program today. Closing shots. I cannot leave it to go just like that. We need to know. There's a recurring question that's come, and part of the things you just take like 30 seconds for us to know about the use of AI. Is it important for me to disclose to a client that I am using AI for his work? I would like to get answers from both parties before we close finally. Is it important for me to disclose the use of AI in producing a work that a client has given to me? Do I have to tell, for instance, the client that I've used AI to produce this legal opinion? Is it important?
Judy, do you want to go, or should I make a quick comment first?
Sure, whichever you want, but I would say that I err on the side of transparency. I think that is best practices that you should. I mean, AI is everywhere, even the client has used it. And you being transparent and upfront actually shows your judgment and your future proof as a lawyer in the cutting edge of technology. And you just say, oh, we used AI to possibly get some research materials, which our junior associate have reviewed and the partner has gone ahead to review it. So they know that you have actually used your best tools and then your best people with only the judgment that a lawyer can do. And I don't think it's wrong to do it, because some people shy from it and say, oh well, but they'll think that I shouldn't charge them more because I used AI and this should have taken X amount of hours. And linking back to what Rotimi said, in terms of you're now charging for value. I mean, that conversation is a whole different deep dive, and I don't want to go too much into it. But lawyers can defensively say, fine, we used AI. Yes, maybe AI cut the bill into XYZ, but the judgment and the analytical skills that were put into it to ensure that we gave you top tier world class advice demanded this price. Again, value, right? So I am on the side, and I always tell my clients to go on the side of transparency, because if anything goes wrong, then you're not, caught out saying, oh, well, I didn't tell my client that I used AI. You're now stuck with, your hands behind your back and you're being defensive, or reactive rather than being proactive by just being transparent about it.
Thank you. Good answer. Rotimi, you want to add, or is that
Yeah,
sufficient?
all supported. Just to add a little bit of nuance now. I'm all for transparency, and I'm not one of those people that shy away. I've had times when I've made presentations and I tell folks, guys, this slide, by the way, the slide that I have up here was developed by an AI, right? But every input that I put into it came from me. So I told Notebook LM, this is what I want to talk about, turn it into a slide. And that's what you see here, right? So I am not shy about disclosing. Now for clients, so long as your use of AI will materially affect the work you are doing for them, disclose. In fact, disclose upfront. Let it be in the engagement letter so that you're not having an awkward conversation later. Oh, in this firm, we use AI responsibly to do this level, but we bring in our A game, human judgment, da, da, da. I mean, put it in a way that is just neat and it's not distracting as well in your engagement letter. That's what I would say. So that, I mean, at the end of the day, you don't go telling your client every time you did a Google search, right? Oh, I went on Google to check, right? So I think that'll be absurd. And I don't think anybody is suggesting that. But do it in a neat way, right? Such that you are covered. And so, yeah, that's all I wanted to.
Okay, so on a final note, we'd like to, unfortunately, Mr. Subena Urijipe could not join us today, but he's the brain and the person that's facilitated all of this. And for those that are still on this call, please put your hands together for Mr. Rotimi Ogunyemi and Judith Olo. They have done this without receiving a dime from the Practical Training Academy. They have donated their time, and they have also given us valuable information and skills that have been acquired. So from the depths of our hearts, we say a very huge thank you. Until the next time when the TPTA brings you another training that's good quality always, we would like to say goodbye to all of you and thank our facilitators again. And I hope that you'll also be available the next time we come with another training opportunity. Thank you all for being a part of this. Thanks.